दोस्तों नमस्कार। मैं एडवोकेट वीपी सिंह आपका अपने चैनल पर स्वागत करता हूं। दोस्तों 15 अगस्त को आप लोगों ने लाल किले के प्राचीर से प्रधानमंत्री नरेंद्र मोदी का भाषण सुना होगा। उस भाषण का एनालिसिस मैंने अपने चैनल पे एक वीडियो में किया है। मैं यहाँ पर प्रधानमंत्री मोदी के लाल किले के भाषण के बारे में बात नहीं करना चाह रहा हूं। मैं आर्टिकल 370 के एब्रोगेशन के बारे में जो सुप्रीम कोर्ट में मामला चल रहा है उसके बारे में बात करना चाह रहा हूं। दोस्तों आपको मालूम होगा कि बीजेपी ने अपने घोषणा पत्र में शुरू से ये रखा था कि हम जब भी सत्ता में आएंगे आर्टिकल 370 को खत्म करेंगे। 2019 के इलेक्शन में भी उन्होंने यही रखा था और उसी के मद्देनजर अगस्त की 5 तारीख को आर्टिकल 370 को पहले राज्यसभा में बिल पेश करके खत्म किया गया, फिर लोकसभा में पेश किया गया, उसके बाद में राष्ट्रपति ने उसको भाषण दे दिया। हमारे यहाँ का जो लेफ्ट लिबरल कबाल है, जिनको इस देश की उन्नति के बारे में या देश की प्रगति के बारे से बहुत तकलीफ होती है, जो हमेशा एंटी सनातनी, एंटी हिंदू प्रोपेगेंडा चलाते रहते हैं और बाहर से पैसा लेते हैं, उन लोगों को ये चीज नागवारा गुजरी। उसमें कुछ लोग ऐसे हैं जिनके नाम मैं लेना चाहता हूं, जैसे एक प्रशांत भूषण सुप्रीम कोर्ट के सीनियर एडवोकेट हैं, कपिल सिब्बल सुप्रीम कोर्ट के सीनियर एडवोकेट हैं, दुष्यंत दवे सीनियर काउंसिल हैं, राजीव धवन सीनियर काउंसिल हैं, और ऐसे ही पूरी एक जमात है जो कहने के लिए तो हिंदू नाम के हैं लेकिन हमेशा वो एंटी इंडिया, एंटी हिंदू स्टांस रखते हैं। इन्हीं लोगों ने अयोध्या जन्मभूमि के बारे में, राम जन्मभूमि के बारे में जो अयोध्या केस चल रहा था उसमें भी बाबरी मस्जिद का ही फेवर किया था और गवर्नमेंट की खिलाफत की थी, हिंदुओं की खिलाफत की थी। कल यानी कि 16 तारीख को और आज 17 तारीख को दुष्यंत दवे साहब ने अपना सुप्रीम कोर्ट में जो आर्गुमेंट है वो पूरा किया है। उसकी रिकॉर्डिंग या क्लिप मैं बाद में दिखाऊंगा। पहले मैं आपको ये बता देना चाहता हूं कि जिन लोगों ने सुप्रीम कोर्ट में 370 के खिलाफ, आर्टिकल 370 के एब्रोगेशन के खिलाफ पिटीशन डाला था, उसमें एक आईएएस ऑफिसर शाह फैजल थे जिन्होंने यूपीएससी में सिविल सर्विसेज का एग्जाम टॉप किया था और बाद में उन्होंने सर्विस से इस्तीफा देकर के एक पार्टी भी बनाई थी जिसमें उनके साथ जेएनयू की स्टूडेंट एक्टिविस्ट शैला रशीद थी। शाह फैजल ने नौकरी वापस ज्वाइन कर ली और 370 आर्टिकल 370 के जो हटाने का पिटीशन था उसको सुप्रीम कोर्ट से विड्रॉ कर लिया। अभी वो आज के डेट में नौकरी में है। 15 अगस्त 2023 को शैला रशीद ने जो प्रधानमंत्री की और आर्टिकल 370 हटाने का जो सपोर्ट किया है, प्रधानमंत्री का जो बड़ाई की है और आर्टिकल 370 का जो सपोर्ट किया है, वो आश्चर्यजनक है। मैं अचंभे में हूं कि सुप्रीम कोर्ट में हियरिंग चल रही है, एक पिटिशनर जो नौकरी छोड़ करके पिटिशन डालता है वो वापस नौकरी में आ जाता है, दूसरे पिटिशनर जिसने भी अपना पिटिशन विड्रॉ किया है और वो जो धुर विरोधी, मतलब घोर विरोधी मोदी की और बीजेपी की है, उसने भी मोदी का सपोर्ट किया 15 अगस्त को और आर्टिकल 370 के एब्रोगेशन को सही ठहराया है। अब मैं आपको कुछ न्यूज आइटम बताता हूं जो देखिए कि शहला रशीद ने क्या बोला है। मैं इन्हीं के जो फेवर की साइट्स होती हैं वहां से लेता हूं, जिससे कि आप लोगों को ये ना लगे कि मैं बीजेपी समर्थक कोई वेबसाइट का सहारा ले रहा हूं आपके सामने रखने के लिए। ये देखिए, ये क्या है, द kashmiriat.co.uk का है, ठीक है। द कश्मीरियत क्या लिखा हुआ है, देखिए, द कश्मीरियत, जर्नलिज्म एज ब्रेव एज टू बी, फॉर्मर जेएनयू एक्टिविस्ट शहला रशीद प्रेजेंट जैन के एडमिनिस्ट्रेशन ह्यूमन राइट रिकॉर्ड। देखिए क्या बोल रहे हैं, ये है शहला रशीद, देख लीजिए आप इसकी शक्ल। फॉर्मर जेएनयू, ये खालिद उमर खालिद के साथ में भारत तेरे टुकड़े होंगे बहुत आगे थी। इवन शाहीन बाग में और जो दिल्ली में दंगे हुए थे उसमें भी ये काफी आगे थी। जामिया मिलिया में जो तमाशा हुआ था उसमें बहुत आगे थी। क्या लिख रही है, फॉर्मर जेएनयू प्रेसिडेंट एंड स्टूडेंट एक्टिविस्ट शहला रशीद नोन फॉर हर एंटी मोदी स्टैंस हैज ऑन ट्यूसडे मींस 15 अगस्त को praised the Prime Minister Narendra Modi, central government and Lieutenant Governor Manoj Sinha for improving the human right record in Kashmir. However, inconvenient it may be to admit this, the human right record in Kashmir has improved under the Narendra Modi government and the office of LGJK administration by a purely utilitarian calculus. The government clear stance has helped save lives overall. That's my angel, she posted on X, earlier known as Twitter. She said so while quoting a post by NI in which Rais Mattu, brother of terrorist Javed Mattu, said that he waved the tricolor from his heart. Rashid was earlier associated with the student wing of Communist Party of India and then returned to the Kashmir Valley on 2018 to join Shah Faisal's political party. The two had filed a petition to safeguard the special status under Article 335 and 37. However, later they withdrew petition. Shah Faisal, who had quit IS in the 2018, was reinducted into administration service last year. ये इनका है। अब देखिए और कहां पर क्या क्या बोल रहे हैं। ये तो इनकी न्यूज हो गई कश्मीरियत की। अब मैं आपको दिखाता हूं और न्यूज क्या है। ये मिंट है, देखिए मिंट क्या बोल रहा है। ये भी एंटी मोदी स्टैंस लेता है, पूरा लेफ्ट लिबरल कबाल का ये है। 1 मिनट के रीड है इसमें। ये है शहला रशीद, देखिए बैठी हुई है। Shehla Rashid has surprised many by offering praise to the Narendra Modi government, the center, and the Lieutenant Governor of Jammu Kashmir for their efforts in improving the human rights situation in the region. This unexpected commendation was delivered by the human rights advocate on August 15, making a significant departure from her previous criticism of the government action in Jammu Kashmir. Taking to the X platform, formerly known as Twitter, Rashid expressed her approval of the clear stance taken by both the Modi government and JK administration, which she believes has contributed to the preservation of life. However, inconvenient ये लिख रही है, ठीक है, वो जो मैंने अभी पढ़ के बाकी सब बकवास कर रहे हैं। Rais Mattu interview. Shehla commendation coincided with her sharing an interview featuring Rais Mattu, the brother of Hizbul terrorist Javed Mattu. This interview emerged following the circulation of a wide leak. ठीक है, तो ये हो गया प्रिंट। अभी मोद इसका अब देखते हैं। शेखर गुप्ता साहब का भी एक चैनल है प्रिंट, उसको देखते हैं, उसमें भी कुछ लिखा है क्या। ये डे टू डे है, मैं इसको पढ़ना नहीं चाहता, ये तो बेकार की बातें करता रहता है। पेपर चैनल है, देखिए ये है हिंदुस्तान टाइम्स जैसे स्टूडेंट दिस एक्सपीरियंस यू टर्न पिटीशन चैलेंजिंग आर्टिकल। ये महीना पहले की बात कर रहा है, ये 2 दिन पहले। इन शॉर्ट कश्मीर मैंने आपको दिखाई दिया। बोल्ड न्यूज, ये देखिए बोल्ड न्यूज में क्या बोल रहा है। PM Modi's magic worked in Jammu Kashmir. Even critics like Shehla Rashid loud policy on Kashmir. कविंदर गुप्ता जी हैं ये वहां के डिप्टी चीफ मिनिस्टर थे पहले के। एससी ड्रॉप शेला रशीद साहब एक महीने की बात है। ब्यूरोक्रेट एक जेन्युइन लीडर है ऑन न्यूटन दिस चैलेंजेस, एक महीने पहले की बात है ये सब पहले की बातें हैं, मिंट में है, फिर पहले की बातें हैं, सारी के सारी पहले की बातें हैं। देखो पहले क्या है। अब मैं आपको दिखाता हूं कि सुप्रीम कोर्ट में जो हो रहा है उसमें दुष्यंत दवे साहब क्या आर्गुमेंट कर रहे हैं। दुष्यंत दवे साहब इतना जहर उगल रहे हैं, इतना जहर उगल रहे हैं जो नॉर्मल एक हिंदुस्तानी के बस का नहीं है। माना कि दुष्यंत साहब बहुत नामी गिरामी वकील हैं, लेकिन जो 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 पॉइजन वो, ठीक है, उनके नरेंद्र मोदी से कुछ पर्सनल होगी क्योंकि वो बड़ौदा के हैं, गुजरात के हैं, लेकिन जिस तरीके से वो सुप्रीम कोर्ट में मोदी के खिलाफ और सरकार के खिलाफ जहर उगल रहे हैं वो आप देखिए और अपने आप एनालाइज करिए। आपको खुद समझ आ जाएगा कि इस आदमी के अंदर सिर्फ मोदी के चक्कर में कितना जहर घुसा हुआ है। मोदी के चक्कर में ये पूरी हिंदुस्तान की वो कर रहा है, खिलाफत मतलब अपोजिट कर रहा है। मैं आपको दिखाता हूँ ये भाई साहब का। कल मैंने कोशिश की थी इसको लाने की। आगे ध्यान से सुनना, 40 मिनट का कल का, मतलब ये 16 तारीख का प्रोसीडिंग है, फिर मैं 17 तारीख की प्रोसीडिंग में जाऊंगा। मैं अपने आप को हटा लेता हूँ जिससे कि आप लोगों को फुल स्क्रीन दिखाई दे कि ये क्या बोल रहा है। ध्यान से सुनिएगा, फिर बाद में मैं 17 तारीख का दिखाऊंगा, कल मतलब आज का। ये है भाई साहब दुष्यंत दवे साहब। ये करीब 40 मिनट का या 45 मिनट्स का है इनका। ध्यान से सुनिए क्या बोलते हैं।
Allow me to begin with this, Lord, profound words of Justice Aaron Barak, or the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review as way back in 2002. Since, Lord, we are expounding Constitution, these are extremely apt words. And I quote him: the task of expounding a Constitution is crucially different from that of construing a statute. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. Now, Lord, 370 is perhaps the most brilliant for articulation of statesmanship on the part of the constitutional framers. You are at a time when the calls for plebiscite in Kashmir are being raised. You are at a time when raiders are raiding in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when India is just being born as a dominion nation. At a time like that, it was a brilliant compromise that was arrived at, which led to producing this article, which persuaded the people of Jammu and Kashmir to accede to India. We gave them a promise. You cannot breach that promise in the manner that you have done, or for that matter, at any point of time. And that's why, Lord, what Dr. Dhawan very rightly points out, that Lord, ultimately, each Lord, article of the Constitution, Lord, deals with this kind of diversity, which, Lord, if we were to start tinkering with, then, Lord, nothing will be left of the Constitution. So, Lord, your Lordships may have to consider, Lord, and my respectful submission, three, Lord, submissions. One, that Article 370 is a piece of, Lord, unusual, Lord, draftsmanship. It is temporary, but it is not temporary by efflux of time as most temporary statutes are. It is temporary by object, the purpose. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains for the president to exercise. So, Lord, it's going to be my respectful submission that 373, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in Lord the CO 44. That's the end of the story. Lord, your Lordships have taken the view right from federal court, and I will show, Lord, series of judgment, that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then, Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then, Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, Lord, that's the view, Lord, 8 of your Lordships have taken in Berubari's case, where your Lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your Lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till, Lord, 6th of August 2019 should have been, Lord, repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that, Lord, the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your Lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on Constitution. So, Lord, you have a government in, Lord, association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. You, Lord, Parliament then apparently takes control of legislative and executive functions, and then you say, now president will exercise all powers into one and, Lord, pass orders under 370. Lord, what more classic example of abuse of power than this can be? Lord, as Chief Justice Pope said, Lord, way back when the fight began with the king, that, Lord, king can do everything except making a man a woman and a woman a man. Lord, surely President could not have, Lord, exercised these powers under 373, assuming himself to be everything. What has been pointed out at great pains and very brilliantly, that Lord, 356 is a temporary provision. Now, Lord, 356 being a temporary situation, can you take actions which are permanent, Lord, or permanency, or permanent in nature? Forget anything else. Because Lord, 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, Lord, to do this, Lord, in my respectful submission, it really strikes at the very basic, Lord, features of our constitution. Democracy, federalism, Lord, Government of India in their affidavit before your lordships categorically admits this, and this is very important, Lord, the counter, which I'll read at Lord appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their, Lord, profound statement. Then, Lord, they try and, Lord, they say that, Lord, ultimately, that what we have done is because of national interest. However, nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, Lord, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start not disintegrating states into union territories in this manner, no state will be safe in this, Lord, under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. This is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the Constitution of India, for federalism, for very existence. That, Lord, it will really be giving now this kind of a power to, Lord, a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in Coelho, your lordships have, Lord, very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on. So I like to create, Lord, this atmosphere of fear all around. Nobody, Lord, one thing I must tell you, Lord, is very interesting, Lord. Very few people, Lord, way back on 27th May 1949 in the Constituent Assembly, Lord, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not, because everybody felt that they should be present. So Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement, which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now, please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised, and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when you have now, as your lordship said very rightly, question about sovereignty, you can acquire a new land by either accession or by cession or by occupation. In each of these cases, you can take away complete sovereignty, as my Lord the Chief Justice observed. But what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition? What happens there? There, Derubari says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need 50% of the states to agree to that provision. So these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So it is very therefore important for us to understand that this is not just about Jammu and Kashmir. Jammu and Kashmir was, is and will always remain part of India. But the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions, how do you interpret those terms and conditions? So your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampat Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this, and President has accepted. So both ways your lordship's court in these two judgments do not give a complete finality to what is the eventuality under Article 370, sub-Article 3. So in my respectful submission, this calls for a very different kind of approach than what government of India would like your lordships to take. Well, that's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then it may happen in another state and you might be called upon to do that again. So the power cannot be exercised because of certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered with in that fashion. So how do you make them durable? You make them durable by really understanding. But the need of the hour was that we wanted Kashmir to get into us, Jammu and Kashmir. So at that point of time, we were left with no option but to accept what they offered us. Otherwise, we were afraid Maharaja might run away there was one fear that he might go to Pakistan. He might join Pakistan. So Lord, this nobody knows what exactly was happening, but who were the people who really were aware? The constitutional framers. And Lord, Dr. Iyengar's exposition of 370 is really the complete answer. Although Lord, I am conscious that Constituent Assembly debates may or may not be relied upon as Lord, but it gives a complete answer to what government tells us on Lord 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of his. So, whichever way one looks at this provision, in my respectful submission, this controversy needs a very, very delicate approach from your lordships, so that we do not end up creating a situation. Today, let us assume, for the sake of argument, that today this decision is in national interest. Let us assume, for the sake of argument. Tomorrow, some other political party in power with majority may try and take a decision which is not in national interest. You have to therefore lay down law which will stop all these exercises for all times to come. And that's where constitutionalism comes into play. And I beseech your lordships, with all humility at my command, that your lordships may therefore look at it this way. Now, take therefore, in this regard, kindly turn straight away to one judgment of your I have a compilation of judgments which are new, but you can also, Prasanna, you can add them. Well, we can. It is already with Prasanna. I can add them with just in 1 second, if your lordships permit.
Is part of the existing compilation now?
It's not with your lordships, it's with the learned courtmaster, volume 30. 130, case law compilation.
So what is volume 29? We stop at volume 28.
These are judgments only.
Judgments are in the compilation?
Dr. Dave is.
Mr. Dave. Sorry, Mr. Dave. I'm sorry.
Many of them are, but 5 of them are not. Which your lordships, our research goes on all the time.
That's Mr. Dave, but at some point of time you have to freeze it all. Otherwise,
these are judgments. Your lordships can't certainly stop us from fighting judgment.
But
submissions, yes, I agree. But
even judgments, should it not be frozen when you submit written the compilation?
It's not easy to do it. And let me tell your lordships honestly, because this is a thinking process. We are constantly thinking and constantly rethinking and rethinking and rethinking. Not to find 5 judgments, I have seen more than 500 judgments. I can assure your lordships.
If we apply this principle to ourselves on the lighter side, then we'll keep on thinking, not produce any judgment, and keep on thinking only.
Lord, your lordships, once the matter ends, certainly we'll be thinking many a times over.
Yes, but we see.
But at some time we have to also say, all right, now
that's
this is the guillotine. Now I'm not going to think anymore.
All right, when my arguments are beginning.
All right, but if so many of your judgments are repeated in the compilation already,
I'm not repeating. Those are there. Those are
5.
there.
Which are the 5 judgments which are not in? Then just the judge.
Judgments which are already given, I'm not.
Actually, the back office work has to be done before the argument.
Much before the arguments, otherwise it becomes impossible.
The problem is if you are a singular counsel arguing.
Lord, once the debate begins in the court, your lordships put questions.
Mr. Dave, what happens is that's why if we don't do this, essentially difficult matters will never get argued because the whole purpose is to restrict time. If you don't restrict time, we cannot carve out time for big matters.
Well, I have promised 1.5 to 2 hours, I'll finish it.
I don't know.
I'm not going to take a minute
Mr.
from-
Dave,
Nahin.
if you are the only counsel, it doesn't really make so much of a difference.
Nahin.
Because you added something, subtracted something. When the multiple counsels, 10 counsels, 12 counsels, each person starts doing it. Where do we go? This is the concern. It is not that we wanted to shut
Law
out. this
declared by
system.
this court, my lord, your lordships would always like to see. It's law declared by your lordship's court, my lord.
No, but I mean, there has to be a certain procedure also and orderliness in making
Every year, SEC online creates some 19-20 volumes. This is another problem.
Well, I'm sure, my lord, when your lordship directed us to give submissions, we never thought that, my lord, so far as judgments are concerned, because it's a constant research. Nobody can, my lord, do it at one go. You are trying to find out again and again and again answers. Questions fall from your lordship's, my lord, bench. So, my lord, to that, your lordship rightly asked about sovereignty.
volume 20. 2 volumes, Ms. Dave.
I don't know, 29 is by
29 is Mr. Nowadays. That has also not been allowed by the board.
This is the problem. How can we do this?
Then how many volumes will we have actually?
It is
We should be actually having one volume now of case law.
28.
My 28 was allowed already earlier, but 30 is not an additional one. How many judgments? I have brought printed copies also, if your lordships like.
So volume 30 is 5 judgments.
5.
'29 also has just case law, right?
Yes, yes, ma'am. There are no submissions. These are only judgments. 28, 29, 30 are case law compliance.
All right, you can.
No, my apologies for it, but
What sauce for the goose is not sauce for the gander. So you will not.
I'm sure, my lord, Mr. Mehta will definitely like to cite, my lord, new judgments to
I
counter
don't
us.
think so.
It is-
He's not saying that I'm going to cite it. Don't give him ideas.
But his smile tells us otherwise.
I learned it when they're saying.
What is it that you want to cite? All right, Mr. Dave, let's quickly run through it. Give us, give us those. Why don't you give us the soft copies? Huh?
It's in the drive.
यहाँ पर है। Judgments or
No, yes, my lord, I would like to.
fellowship charity? Is it that you want to, why don't you then give the judgments in 10 minutes that we have today? You can really give us the framework. What are the judgments you want to cite? What is the principle? Just formulate the principle.
As I said, not the 3 points that I want to urge. One is that not 370 by itself, Lord, is a self-exhausting provision.
All right, then what are the judgments? Just tell us the citation. Volume 29 page.
Lord, 1959.
Volume
SCR,
30, right? Volume 30.
PDF,
Just give us the PDF page.
Lord, PDF page 16161.
No, it can't be 16161.
page 2. Volume 30, page 2. You proper page. You sit down and you.
Volume, what is the site, what is the name
So
of the
this
case?
is Dalmia Dadri Cement versus CIT. But this interpreted this very broad letter of accession and said that this is a treaty. And more,
Para?
yes, more paragraph 3, 5, and 8. 8.2.
8.2.
Yes.
Why don't you read out the relevant part, Mr.
Yes.
Let me read it out.
So, Lord,
Yes.
now, Lord, here, your Lordship say, and I what fell from the Honorable Chief Justice.
What did it
Lord-
interpret? Interpreted?
Sorry,
What did it interpret, you said?
Lord, interpreted the accession agreement and Lord held it to be a treaty, and then said sovereignty should transfer.
Sovereignty transferred.
Yes. But Lord, in the subsequent case, Lord, in Berubari, which is already on record.
Now, Berubari, where will we get the site?
Yes, Lord, Berubari is at, Lord, I'll tell you, Lordship.
Which case law compilation?
PDF page.
Of volume?
Yes, Lord, it is PDF page 13, CLCP 492.
No, what is the volume?
13, page 492.
Volume 30 or 13?
13,
Volume 13, page?
92. 492.
Let's
Now,
go.
Lord, this will have to be read in extenso because this is a brilliant, Lord, exposition of a treaty and why, my Lord, your Lordships held that you cannot get out of this treaty except by constitutional amendment. Give me the page when I actually interpret the resolution.
Volume 30.
Don't ask.
Volume 13?
I am Lord. Your Lordship knows, Lord, that Mrs. Dave had to assist me. Your was caused embarrassment to your Lordships at that point of time. Lord, my Lord, that's why I proudly call myself technologically
It's
challenged.
so simple, Mr. Dave. Just try, give it a try for one day and you'll never go back.
Yeah, try to encourage you on the lighter side by saying I had an equivalent mind block to it. And among the mind blocks I had, I used to tell the chief, say, don't deprive me the privilege of, after a miscellaneous matter, throwing the file down. That's the only privilege a judge has after a badly argued matter. But but in these kind of matters, I mean, having done it last time, I realized that the volumes become so many in a small matter, it's fine, but in a bulky matter,
No,
it works better.
This is the thing.
It works better.
Now,
So we are encouraging you, Mr. Dave, that please get on board.
Well, I am giving your Lordship PDF pages.
But that is what your junior is relaying to you. You have to give it to us yourself.
I don't know that Lord, I don't take away please from me.
Volume 13, page 492. Berubari.
Yes, madam. I turn to. In view of our conclusion. Yes. Lord, yes. What para 31? My lords have got it. May I read it, please? What then is the nature of the treaty-making power of a sovereign state? That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. As we have already pointed out, it is essential attribute of sovereignty that a sovereign state can acquire foreign territory and can, in case of necessity, cede a part of its territory in favor of a foreign state. And this can be done in exercise of its treaty-making power. Cession of a national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in fact in all cases of cession. The inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate within a certain period in favor of the inhabitants of a ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign against their will. But now see more these words, and I place them for your lordship's acceptance. But though from the human point of view, great hardship is inevitably involved in cession of a territory by one country to the other, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question is to how treaties can be made by a sovereign state in regard to cession of national territory, and how treaties, when made, can be implemented would be governed by provisions in the constitution of the country. Stated broadly, treaty making power would have to be exercised in the manner contemplated by constitution and subject to limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on the provisions of the constitution itself. We must therefore now turn to the aspect, that problem, and consider the position under our constitution. In dealing with this aspect, we are proceeding on the assumption that some legislation is necessary to implement the agreement in question. Then Lordships may omit 5-7 lines and please come to the words unlike other federations.
But before that, something very interesting. The Attorney General, appearing for the Union of India, in that case, argued that there is something called the basic structure.
Correct.
Just see that the learned Attorney General asked us to bear in mind the special features of the basic structure of the Constitution
Correct.
in construing the relevant provision of Article 3. He contends that the basic structure of the Constitution is the same as that of the Government of India Act 1935.
That's how, not right, 60. 60, right?
Yes.
60. Mr. Setalwa, he alone could do that. Now, please see, Lord. Unlike other federations, the federation embodied in the said act was not the result of a pact or union between separate independent communities of states who came together for certain purposes and surrendered a part of their sovereignty. The constituent units of federation were deliberately created, and it's significant that they, unlike the units of other federations, had no organic roots. Hence, in the Indian Constitution, by contrast with other federal constitutions, emphasis on preservation of the territorial integrity of constituent states is absent. Now, Lord, this is important. But now, Lord, kindly turn to paragraph 44 at page 515. How does it begin? Yes.
Just read the lower portion.
Yes.
Also.
Just read what, Lord?
The paragraph 32, the lower portion.
In fact, you can start reading
Yes.
from in fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines. Is it directly goes against you?
That as a result of States Reorganization Act in place of original 27 states and one area which were mentioned in Part D in first schedule to the Constitution, there are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. The changes thus made clearly illustrated the working of peculiar and striking feature of the Indian Constitution. There may be some force in this contention. It may therefore be assumed that in construing Article 3, we would take into account the fact that Constitution contemplated changes of territorial limits of the constituent states, and there was no guarantee about their territorial integrity. Undoubtedly. Question is, can they be turned into union territories? Of course, they can be changed territories. No difficulty. That's express provision. And Lord, the word, if your lordships were to read the word union territory for every word state in Lord Article 3B, then Lord, result will be absolutely very, very unbelievable. So, Lord, although the explanation says that state includes union territory, but if you were to read it,
This is the way. I don't want to interrupt, but if it can be done for the state, why not for union territory? Until unless there's something you can make out otherwise, and when the explanation goes, explanation says state and union territories use interchange.
Lord, I must tell your lordships, I am not dealing with that part of the argument which has
That's
been
fine.
very beautifully done
Okay, then
by
we come down.
my worthy predecessors. But my Lord, I must tell your lordships that what is really worrying me is this. Your lordships are right, it can be done. Question is that, my Lord, if it can be done in Jammu and Kashmir, why can't it be done in Gujarat? Why can't it be done in Maharashtra?
Okay.
So, my Lord,
let's
that's
move further.
something
Let's
which
proceed.
you have to bear in mind.
Let's
It can't
proceed
be
further.
done. Now, Lord, please turn to para 44, straight at page.
I won't fight.
therefore our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purposes of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that the law necessary to implement the agreement has to be passed under Article 368. Then Lord 368 is extracted, and then your Lordships may kindly turn to my Lord page 516, para 47. On the other hand, now, my Lord, this is very important. Just see, my Lord, how your Lordships were viewing, my Lord, democracy. On the other hand, it's to be passed under Article 368. It has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house.
Like we'll come tomorrow.
So, Lord, look at it this way. Your Lordships not construe even majority, not to be major parties of the house,
Now,
meaning that you must carry everybody on board.
After this, we have Mr. Dwivedi will be arguing, or Mr. Nafik. Like between the three of you, if you could please request that, could you apportion the time so that, by lunch tomorrow we have completed with Mr. Dave, Mr. Dwivedi and Mr.
Said 2 hours, but I'll finish in 1.5 hours.
Portion is not there. I have a portion is not there. But I state organization.
So David, could we do this?
Wait, please, your Lordships. Lord, may I once again request your Lordship to revisit Berubari for a minute? Lord, where we had stopped yesterday. Lord, that is PDF, Lord, volume 13, page 492, at 508, para 31. Volume 13, 492, at 508, para 13.
30.
31, para 31.
PDF 508.
Sorry, my Lord?
PDF 508.
Yes, man.
So the PDF number?
Volume 13, page 492, at 508, para 31. Which I read. I'm
Yes,
just
you read it,
taking
yes.
one line to be read again, to buttress my point.
508.
Lordships may see last 10 lines of that para 31. Last 10 lines. That's not very crucial because that's exactly what has happened. 370 is a clear, I would say, reflection of this viewpoint that 8 justices of this court have taken.
Running page 6038.
My lords have got it?
1 minute, my 6038. running page.
Where is the young intern? Lordship.
We are also in the same.
I know, but there was a
No,
young
that-
intern who was helping Justice Collier.
At least,
I
and
can't
I'm trying
see
to
the
do it
young
myself.
guy.
Justice Kaul and me are totally newcomers to this.
Beware of my Lord Chief Justice, Lord. He doesn't appreciate those of us who are technologically challenged.
So they've become pros now. My two brothers have become pros.
I
Brother Suryakant, I had indoctrinated when we sat together for 2 years. We were together on
went
the
through a
board.
learning experience even yesterday evening while going home.
But not that.
Operating for
Yeah, my Lord Justice Khanna would remember Delhi High Court Lord started it much earlier. That's why Lord, those judges from Delhi High Court are extremely pro.
We've been used to it,
Yes.
been used to it. I think for regular matters, I found it to be extremely helpful. It's very convenient.
I escaped it.
See, some state governments are very supportive. Others, are. I remember the time of the pandemic. I won't name the High Court. They didn't have money to pay for the licenses for this video platform that we were in. So it's so dust cheap. We just withdrew some licenses from the Supreme Court and transferred it to them because they were absolutely in a dire state. And at that time there was a lockdown. It was impossible to run the court without video conferencing.
But if your lordships can carry this into Lord, the lowest of the courts, Mofizil courts, Lord, it would be the greatest contribution
Now,
that your lordships will end up.
phase 3, we have a huge budget, so we are in the process of doing that, setting up our own cloud software for video conferencing.
And Lord, your lordships, there will be at least continuity since all your lordships are here for at least next Lord several years. So now, Lord, last 10 lines of this para. This power it may be added. The words this power it may be added. My lords have it?
Yes.
This
yes.
power it may be added is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question as to how treaties can be made by a sovereign state in regard to a cession of national territory and how treaties when made can be implemented would be governed by the provisions in the constitution of the country. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution and subject to the limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on provisions of the constitution itself. Now, Lord, in my respectful submission, the treaty in question here between the erstwhile ruler and Lord, the Governor General, which ultimately, Lord, that has now been transfixed into Article 370. So, Lord, 370 is an extraordinarily unusual provision. It's never, Lord, I mean, it's something which is so beautiful that, Lord, the constitutional framers felt that how do we give, Lord, a kind of respect, kind of acceptability, kind of, Lord, validity to this, Lord, letter of accession. So they, Lord, devised, as I said yesterday, Lord, it was an absolute, Lord, brilliant statesmanship on their part to bring that into constitution to assure people of Jammu and Kashmir that we mean what we say. We are not going to do away with this. So, Lord, that's why, Lord, this is very important that treaty will have to be interpreted in the light of 370. It's now, Lord, virtually, Lord, transposed into Article 370. Now, Lord, in the light of this discussion, please see, Lord, at page para. Therefore, our conclusion is para 44 below. Page 515, para 44, just first sentence. And this becomes even more important now. Therefore, our conclusion is, and Lord, in my respectful submission, Lord, no, it's a view which is, Lord, inescapable, and Lord, it binds your lordship since, Lord, this is a judgment of a bench of 8 learned judges. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purpose of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that law necessary to implement the agreement has to be passed under 368. Now, concession follows the conclusion. So, Lord, it can't be said that it is on a concession. The conclusion of your lordships is very categorical that legislative power is not possible. Only a constituent power can be exercised in respect of this. And that constituent power is under 368. So, Lord, in my respectful submission, far from President exercising the powers, and I will show, Lord, why President had become functus officio. But not even assuming that 373 survives, which it doesn't, in my respectful submission, even then, the power could only be exercised under the constituent power. No other way. Now, Lord, please. Okay. Yes. Lord, this is a little important because your lordships rightly raised the issue as to the definition of union territories in Article 3. Lord, originally it was not there. It was brought subsequently by, I think, 17th Amendment to the Constitution. But your lordship said states do not include territories. Kindly see that. Page 516, paragraph 47. It would not be out of place to mention one more point before we formulate our opinion on questions referred to us. We have already noticed that under the proviso to Article 3 of the Constitution, it is prescribed that where proposal contained in bill affects the area, boundaries or name of any of the states, the bill has to be referred by the President to the legislature of that state for its use. Therefore, within such period, it is prescribed, it has been heard before us, so and so. Then, Lord, no, I'm sorry. I'm sorry. I missed that page. It's earlier page. Page. It is significant that Article 3. It is significant that Article 3. Page 513, Manoj. My apologies, sincere apologies. Page 513, para 40. My sincere apologies. It is significant that Article 3 in terms does not refer to the union territories. And so, whether or not they are included in the last clause of Article 3A, there is no doubt they are outside the purview of Article 3B, C, D, and E. In other words, if an increase or diminution in the areas of the union territories is contemplated, or alienation of their boundaries or names is proposed, it cannot be effected by law relatable to Article 3. This position would be of considerable assistance in interpreting Article 3C. So, Lord Parliament then amended, and 18th Amendment. That's the joy of having somebody like Lord Gopal sitting next to us. I must not confess to your lordships that I have sufficiently been instructed, briefed, and educated by Mr. Prashant Bhushan in this matter over several sessions. So because he is appearing with me, and so it's something which I must not say that it is. Now, Lord, please turn back to that para that I was reading, para 47 at 516, and your lordships will find in the middle somewhere on the other hand, which is at 10th line from the top, on the other hand. Page 516, para 47, in the middle somewhere, on 10th line from the top. On the other hand, it is clear that if the law in regard to implementation of the agreement is to be passed under Article 368, it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house. And that is a safeguard provided by the article in matters of this kind. Please see the language. But this is the protection your lordships have extended. And I beseech your lordships to extend it further. Beseech your lordships to extend this further. That this is how you can't resort to some kind of executive power authorize president to do this, or do away with everything that Article 3 provides in the garb of Lord 356 powers. It makes complete mockery of constitutional safeguards. Because your Lordship knows what majorities can do. We have seen what happened in 1975. So Lord, this is the check, and that's why Lord, constitutionalism, your Lordship's Lord, duty to Lord the Constitution, to Lord ensure that it is upheld by the executive and parliament in letter and spirit. If they don't do it in letter and spirit, this court will strike it down and must. So Lord, these words, Lord, I now see answers, Lord, to the reference which was sent by the Honorable President. We would accordingly
Really,
answer.
everybody was decided at a time when explanation 1 and explanation 2 were not on the constitutional.
It came as a consequence. Your Lordship said,
They came as a consequence of Berubari
correct,
to take into account what the court held, that the state would not include a
Correct.
union territory.
correct.
So now really that issue will not survive because the whole basis was that state will not include a union territory. And therefore you couldn't see that territory in exercise
Yeah.
of the lawmaking power under Article 3. You had to amend the constitution.
That's what there are two submissions on this. One, that treaty to be interpreted in the light of what constitution provides in respect of that treaty. And two, that if you want to now touch that treaty, you cannot do it by a legislative act. You have to do it in exercise of a constituent power. As I said, Lord, constitution is durable. Lord, if it served the need of the hour on that day, doesn't mean that Lord, that need must be wished away because you have a majority. Lord, in my respectful submission, the argument that Lord government is advancing before Lordships, Lord, does not bear out from plain reading of the constitutional provision. Now, see, Lord, chapter 21, the title, temporary, transitional, and special provisions. Now, Lord, I accept that 370 is temporary because it's titled temporary.
Yeah.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice. And I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's plot, a very express statement before the Constituent Assembly. So Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade, Lord, citizens of a state, a country, at that time an independent state, to cede to you. They agree to session on clear understanding.
There is a question of persuasion by.
Sorry.
It was the Raja Hari Singh who requested the government of India that
I
time.
agree. No question about it.
No, you are
But
saying
the
that
conditions, historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mr. Sibal argued that after 1954, this 370 has become a permanent
Yes.
section of the Constitution.
Now just see, Lord. Just see, Lord, 370. Lord, 370 is, Lord, what? Lord, first and foremost, 370 is, Lord, that, Lord, Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state, meaning thereby all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. We have to begin journey of 370 with that. Then, Lord, they go forward and say in Article, Lord, B, power of Parliament, in Article B2, just a second, Lord. In Article, Lord, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, Lord, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President, subject to this exercise of power under D, and read with the proviso. Provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside an instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, the constitutional provisions are now added by 1C and 1D. Legislative powers are added by 371A. 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in Union list and the concurrent list, which in consultation with Government of State are declared by President to correspond to matters specified in instrument of accession, governing accession of state to the dominion of India as matters with respect to which Dominion legislature may make laws for that. And 2, such other matters in the said list as with the concurrence of Government of State, President may by order specify. Now, my lord, why is it temporary? Please see subarticle 2. Please see subarticle 2. If concurrence of Government of State referred to in para 2 of subclause B, that is legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing Constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision.
So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, my lord, President may exercise powers in consultation with the state government under 1B or my lord 1C or 1D. They said yes, they can, but you place them before Constituent Assembly for a post facto approval. So my lord, it was never intended to be permanent. It is a temporary provision. And brought the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This is a constitutional provision. President can't exercise powers like this and say 370 is now otiose or it stands repealed or it stands withdrawn. Now, in that context, please see Article 3, sub-Article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So, Lord, he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications, and from such date as he may specify. So, Lord, the power is both for President to continue or President to discontinue. Lord, if he wants to continue, we can continue in same fashion or with such exceptions and modifications. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by an exercise which brought a temporary provision, but temporary in terms of the objects, temporary in terms of the actions to be taken, not by flux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Lord, Constituent Assembly, as your lordships have been told, Lord, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued Lord CO in 1954. End of the matter. Where does he then have power to re-exercise that rule? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened. But now governor can send in and we can act on it. But that will be virtually destroying this very express provision. And I respectfully submit that it is impossible to accede to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying, now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article my lord, has lived its life, has achieved its purpose. Now, my lord, 371 survives because, my lord, tomorrow a constitution is amended. And, my lord, new article is inserted, which, my lord, we would like to apply to Jammu and Kashmir also. President then seeks the government's view and then extends the article. So to that limited extent, perhaps this article 371 may be necessary. But 373 is very clear that applicability of Constitution of India per se was only in terms of article 373. And once they decide that, then, Lord, no, it is untouchable. It cannot be revisited. President became functus officio in 1954, so far as 373 is concerned. And your Lordship's court have expressly accepted this position. Lord, in Premnath and Sampath Kumar, both your Lordships have accepted this interpretation. I'll make it, Lord, good to your Lordships. Expressly, your Lordships have said that. And that is, Lord, the view. Now just turn to, Lord, the view of Gopalaswamy Iyengar, Lord. As your Lordships would recall, Lord, Gopalaswamy Iyengar was, Lord, the Diwan or Prime Minister of Jammu and Kashmir for, Lord, many years. Lord, he was later Defense Minister in post-independent India and one of the most respected, Lord, Indians at that point of time. But Lord, he was heading this. Now just see his, Lord, page, PDF page. Which volume? Volume 8, PDF page 1175.
The documents. The document file?
Document file.
What file? Documents volume 8.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
Lord, Lord, that's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been
But
applicable.
if you see the proviso to D refers to other provisions of the Constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the Constitution require the require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders progressively modifying the provisions of the Constitution in relation to the state of Jammu and Kashmir. Which means that, really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life, and what is a temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of us of any constitutional orders being issued progressively from 1954 onwards or 1958 thereafter.
Refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But Lord, subsequently, once the Constituent Assembly goes, Lord, whatever, my respectful.
But then where is the power to alter the Constitution at all?
Lord,
if your argument is right,
Lord,
then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the Constitution in relation to the state of Jammu and Kashmir.
I respectfully.
Which is contrary to what everyone accepted, that
373 is only in respect of, Lord, continuation of 370 or not. Now, Lord, they agree, Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes, Lord, some kind of a permanent decision. Please permit me to reread that, Lord, 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause T shall be necessary before President issues such a notification. So, Lord, idea is that you have to decide as a Constituent Assembly whether you want this relationship to continue or not. So, Lord, they took that decision.
No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to Clause 3 uses the expression recommendation. But the commonality between Clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision and the proviso to Clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to Clause 3, because then it's worked itself out and the substantive part of Clause 3 and Article 370 becomes a permanent feature of the Constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to Clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under Clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Justice of Article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause B of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, Lord, this is temporary within temporary. It is in respect of a situation where, Lord, the Constitution now, a state has just come in, India is now become a republic, Lord, Constituent Assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government, it may give its concurrence and its consultation, but it should be very clear whether people want it. So they said, if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to Clause D continue to operate once the Constituent Assembly completed its task in 1957?
Lord, what has happened is that government also has said in their affidavit, and
or would that power be exhausted once the Constituent?
All provisions of the Constitution, they have applied all provisions of Constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is fully in operation.
But then that is exactly.
We are talking about.
You're right, absolutely, logically. But then why? How do we explain the fact that there were subsequent amendments to the Constitution by the constituent orders?
What?
Because, the provisos to Clause D refer to state government. Clause 2 refers to the Constituent Assembly. And Clause 2 says if the consent of the government was taken before the Constituent Assembly was formed, you have to place it before the Constituent Assembly.
But a wrong practice cannot result in rewriting
we are talking of
provision.
We are talking of a practice over what? Over 46 plus 18. 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed. Then you continue with the practice. It's nobody's case.
That's completely out.
It's,
But otherwise, we will have to
different
say,
argument.
but it is not
we will
petitioner's
have to
case
say
that
that-
no longer amendments of constitution can apply. That's not petitioner's case. Question is, what is it that was not supposed to have been agreed, a promise?
if the power under the proviso to clause 3 has exhausted itself, then equally the power under the 2 provisos to clause D has also exhausted itself.
From moment
In which case, how do we explain the exercise of that power for 64 years?
looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because it, by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of Sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power.
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, lordships are right, that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's
You got the point. We'll move on.
Now just see.
Just 1 minute. Just
Please see, Lord, what your lordships are saying is answered in Lord 371B itself, what my Lord Chief Justice is rightly putting. The power of Parliament to make laws for the state shall be limited to those matters in Union List, concurrent list, which in consultation with Government of State are declared by President to correspond to matters to so and so, as the matters with respect to which Dominion may make law. So that's futuristic. May make law for the state. So any law that is made in future can be applied by the President under 371B. Then Lord, such other matters in the state list as with concurrence of Government of State President may by order specify. So Lord, this is futuristic exercise of power by the President from time to time. Likewise, Lord, in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modification as President may by order specify. So power of President is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the Constitution are important in the opening of the article. Now just turn to Mr. Iyengar's broad statement. Please turn to Lord PDF volume.
Away, whether under the second proviso,
Yes.
D, all the provisions of the Constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government under D, the entire provisions of the Constitution could be made applicable to Jammu and Kashmir?
There could have been, except 370 can't be.
Except
Lord.
370.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
then what remains if everything under the Constitution can be made applicable by exercising the powers under D?
Lord, it needs consultation and concurrence.
That's what if
Yeah.
with the concurrence of
Yes,
the question that is being put
no
is
difficulty. It can be undoubtedly, but the power of removing Article 370 is disappeared.
a different power.
That's an independent. And government union in its affidavit has stated that all provisions of articles of the Constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason, except national security and some violence. They have not given any other reason also. So this has worked. It must continue to work. Now, why it should continue to work? Please see Professor Dr. Iyengar's broad statement. PDF volume 8, page 1175. The words again, the Government of India had come into. Last para at page 1175 minus. Your lordships have got it.
again the Government of India.
Yes. Again, the government, my
Just
Lord
one
Justice Call has got.
Just one.
Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistants. They're very talented.
The quality of assistance they give, especially matters of this nature,
Yes.
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
In fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because their assistance is amazing and their experience, but the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Again, the government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of Constituent Assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state. Now, kindly turn over and please come to Lord page, the last clause, 8 pages later. The last clause refers to what? In fact, right from top, then we come to clause 1178. Then we come to clause 2.
Mr. Dave, the portion you have read is part of the Constitutional Assembly debates relating to the Indian Constitution.
Yes. Part of the Constitutional Assembly debate on 17th of October 1949.
Correct.
Now, Lord, 1178, my lords may turn to.
1178.
Then we come to clause 2. You will remember, then we come to clause 2. You will remember that several of these clauses provide for the concurrence of government of Jammu and Kashmir state. Now, these relate particularly to matters which are not mentioned in instrument of accession. And it is one of our commitments to people of government of Kashmir that no such additions would be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination of Constituent Assembly of the state. Then about one paragraph later, the last clause refers to what may happen later on. Now see this, Lord. We have said Article 211A, which is 238, will not apply to J&K. But that cannot be a permanent feature of the constitution of the state, and hope it will not be so. So the provision is made that when the Constituent Assembly of the state has met and taken its decision both on constitution for the state and on the range of federal jurisdiction over the state, President may, on recommendation of the Constituent Assembly, issue an order that this Article 306A, which is 370, shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, recommendation of Constituent Assembly will be a condition precedent. That explains the whole of this article. Now see next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India. But the bogey is today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a Constituent Assembly in due course, which will go into matters I have referred. When it has come to a decision on the matters, it will make a recommendation to President who will either abrogate 3068 or direct that it shall apply with such modification exceptions or recommend. That, sir, is briefly description and effect of this article. I hope the House will carry it. And House carried it. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
Sayajirao.
Sayajirao. I was shocked to read because Sayajirao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordship knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharshi Aurobindo, who stayed in Baroda for many years, and some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s. So the man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford Cambridge lines. So and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that. Now, he therefore didn't want to. Now, just see, my learned friend wants me to read at page 1177 perhaps, or 1178. Now it is not case. Which page? 1177, last para.
In fact, 1178, see that one para which says, now you will recall.
Yes. That in some of the clauses of this article, we have provided concurrence of government of state feel that in view of commitments already entered into between state and center, they cannot be regarded as final authorities for giving this concurrence, though they are prepared to give it in the interim period. But if they do give this concurrence, this clause provides that concurrence should be placed before Constituent Assembly when it needs, because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was still the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, Lord, that may perhaps
what he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case,
3
really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
Please see that,
Yes.
on C and D at page 1177, clauses C and D refer. Your lordship, see, clauses C and D refer to provisions of Constitution. My lords have it.
Yes.
Clauses C and D refer to the provisions of the Constitution other than matters listed in list 1 and 3. These various provisions have been divided in certain categories. First, according to this draft, is Article 1 of the Constitution will automatically apply. As you know, it describes territory of India and includes amongst territories all states mentioned in Part 3. J&K is one of the states mentioned in Part 3. With regard to other provisions of the Constitution, these will apply to Jammu and Kashmir state with such exceptions and modification as may be decided on when President issues order to that effect. That order can be issued in regard to subjects mentioned in instrument of accession only after consultation of government of state. In other matters, concurrence of that government has to be taken. What your lordships read was in Part 2, because the government was an interim government. So whether that government was rightly giving rightly giving advice or concurring, so they said let people decide to that limited extent. Now, next para. Now it is not the case, nor it is the intention of members of Kashmir government, whom I took opportunity of consulting before this draft was finalized, It is not their intention that other provisions of constitution are not to apply. Their particular point of view is that these provisions should apply only in cases where they can suitably apply, but only subjects with modifications and exceptions as particular conditions of J&K state may require. I wish to say no more about particular point at the present. So that is how the Lord he looked at it. That is how he defined. There is no other interpretation possible. This is the author. And one of the most respected, Lord, eminent citizens of this country. Lord, on 5th of August, President issues a proclamation. Then it is sent to Rajya Sabha. Rajya Sabha sends a recommendation without on the same day. Then Rajya Sabha approves reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. But these constituent assembly debate took place over several years. These are the men and women who are the most brilliant that have ever been born in this country. We owe a permanent gratitude to them. And if we were to interpret constitution as today's governments tell us, we'll be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of this country. And that pain they brought in various provisions to recognize this. It's not the article, is not just a letter. It's the feelings of people of Jammu and Kashmir.
What next, Mr.
Yes.
Davina?
Now, Lord, kindly come to, in this context, the two judgments which I respectfully submit are squarely supports the view that I have. Lord, kindly turn to PDF volume 1, isn't it? At page 8. Premnath called. It's 1950.
Volume 1 of the case.
On October 25, 1947.
Volume
Which page?
Srikanday, volume 1, page 7. Case law compilation.
Para 10. Your Lordships may turn to para 10. Lordships have got it? On October 25, 1947, Maharaja signed an instrument of accession with India, which had then become an independent dominion. By first clause of instrument, the Maharaja declared that he had acceded to dominion of India with intent that Governor General of India, Dominion, Legislature and Federal Court and any other dominion authority established for purpose of dominion shall, by virtue of instrument of accession, subject always to the terms thereof and for the purposes only of dominion, exercise in relation to state of Jammu and Kashmir such functions as may be vested in them by or under Government of India Act and so on. We may usefully refer to some of the other clauses of instrument. Then Lordships may omit all that. And please kindly, thus, last sentence of that paragraph. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my Lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India. Now kindly turn to my Lord. Lord, please turn to paragraph. There is one more argument. Page page 287. Why haven't you written? PDF page 15, para 26. No, where is para? Page 16, para 26. There is one more. No, just before that. Well, just before the paragraph 26, please see last sentence of para 25. We must therefore reject the argument that the execution of instrument of accession of para 26 last sentence. I'm sorry. Why are you confusing? I asked you to write this down and be carefully yesterday. Last part of para 26. We must therefore reject the argument that the execution of instrument of accession affected in any manner the legislative, executive, and judicial powers in regard to government of state of which then vested in ruler of the state. So for all purposes, your Lordship's court recognized that not he was the state who wielded all the powers. And his instrument of accession didn't take away those powers, although he became part of India. Now see, my Lord, next paragraph. There is one more argument which has been heard before us on the question of Maharaja Hari Singh's powers. It said that Maharaja issued proclamation on March 5, 1948, replacing emergency administration by a popular interim government headed by Sheikh Abdullah, constituting council of ministers who were to function as cabinet and act on principle of joint responsibility. He virtually introduced a popular democratic government in state, surrendered his sovereign rights, and became constitutional monarch. There is no substance in this argument. The proclamation merely shows under pressure of public opinion and as a result of difficult and delicate problem raised by tribal raid, Maharaja very wisely chose to entrust actual administration government to charge of popular cabinet. Then Lordships may omit all that and please kindly come to Lord page. Lord, since Mr. Chatterjee has resigned, page para 32. Page 18. Since Mr. Chatterjee has strongly relied on application of Article 370 of the Constitution to the state in support of his argument that Yuvraj has ceased to hold plenary legislative powers, it's necessary to examine provisions of this article and their effect. But these two judgments are a complete answer to what has happened. And these judgments bind your Lordships. There is no reason to differ from this view. This article was intended to make temporary provisions with respect to state of Jammu and Kashmir, then so and so. Now, Lord, please see after the article, Lord, clause 1B of this article deals with legislative power of parliament to make laws for the state, and it prescribes limitations in that behalf. Under para 1, subclause B, clause 1, parliament has power to make laws for state in respect of matters in union list and concurrent list, which president in consultation with government of state declares to correspond to matters specified in instrument of accession. Whereas in regard to other matters in the state list, parliament may by under para 2 have power to legislate for the state after such other matters have been specified by his order by president with the concurrence of the government of the state. It is significant that para 1 refers to consultation with government of state while para 2 requires concurrence. Having thus provided for consultation with and concurrence of government of state, the explanation shows that government of state means in this what it means in this context. It means, according to appellant, not the Maharaja acting in his himself in his own discretion, but person who is recognized as Maharaja by president acting on advice of council of ministers for this. It is said on this explanation that appellant has placed great reliance. Subclauses C, D, and 1 of article provide respectively provisions of article 1. And the present article shall apply in relation to the state, and that the other provisions of the constitution shall apply in relation to it, subject to exceptions and modifications specified by presidential orders. These provisions are likewise made subject to consultation with or concurrence of government of state respectively. Having provided for legislative power of parliament and for application of articles of constitution to the state, Article 372 prescribes that if concurrence of government of state required by relevant clauses has been given before Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly. For such decision it may take. This clause shows this, Lord, what your Lordships are rightly, Lord, worried about. This clause shows that constitutional makers attach great importance to the final decision of the Constituent Assembly and continuance of exercise of powers conferred on the Parliament and President by very relevant temporary provisions of 371 is made conditional on the final approval by said Constituent Assembly in said matters. So what 371 continues with that. Once more it continues, then 373 becomes OTOs. Clause 3 authorizes President to declare public notifications that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by President only if Constituent Assembly of State makes recommendations in that behalf. Thus, proviso to clause 3 also emphasizes importance which was attached to final decision of Constituent Assembly in regard to relevant matters covered by 370. Now, my lord, please turn to next para on the same page on the said construction. Para 38. Para 38. But my lord, please omit first 10 lines or 5 lines. 5 lines. The constitution makers were obviously anxious. My lords have that? Para 38,
Yes.
fourth or fifth line. The constitutional makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself, not by Indian Parliament. State itself. And that is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. It would not be permissible or legitimate to hold that by implication this article sought to impose limitations on plenary legislative powers of Maharaja. These powers had been recognized, specifically provided by the Constitution Act of the state. It was not and could not have been within contemplation of competence of constitutional makers to impinge even indirectly on the said powers. So not from Maharaja, they got transferred to Constituent Assembly, those powers. So they say that you can't impinge on those powers. It would be recalled that by instrument of accession, these powers have been expressly recognized and preserved, and neither subsequent proclamation by Yuvraj Karan Singh adopting as far as applicable the proposed constitution, nor constitutional order subsequently issued by President purported to impose any limitation on said legislative powers of the ruler. Please see this. These decisions, Lord, I have completely answered long back. What form of government the state should adopt was a matter which had to be and naturally left to be decided by Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf. Now see these words. Until the Constitution Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by instrument of accession. It would therefore be unreasonable to assume that application of 370 could have affected or was intended to affect plenary powers of Maharaja in matter of governance. In our opinion, appellant's contention based on this article is therefore rejected. Now, Lord, please turn to this para because this is a little important. It is difficult to see how this article purports. Para 40. Para 40, but Lord, after 12 lines. The word starting with the constitutional position. 10, 12 lines. How many? PDF 21.
Altogether issue whether the Yuvraj could have really issued the
go to Sampat Prakash now.
Sampat Prakash.
Same volume. It starts at page 27 at 30. 27 at 30. On the earlier page at 29, but at 30, please see the answer. Learned counsel urged, in this background, Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed.
You are reading paragraph?
Learning sounds okay.
Page 30, para 4. Para 4.
Just the paragraph above para 5.
Yes. Learned counsel urged that this background Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed and the will of the people of J&K had been expressed, and thereafter this article must be held to have become ineffective, so that modifications made by President in exercise of powers under this article subsequent to enforcement of Constitution of state would be without any authority of law. Now please see the answer to that. Next paragraph. We are not impressed by either of these two arguments advanced by Mr. Ramamurthy. So far as historical background is concerned, Attorney General appearing on behalf of government also relied to urge that provisions of Article 370 should be held to be continuing in force. Please see that note. Mr. Daftari. Should be held to be continuing in force because situation that existed when this article was incorporated had not materially altered, and purpose of introducing this article was to empower President to exercise discretion in applying Indian Constitution. There is considerable force in this submission. Legislative history of this article cannot in these circumstances be of any assistance, that this article became ineffective after Constituent Assembly of the state had framed the Constitution.
Yeah. Completely against you, Mr. Dave.
Please see that. There are other much stronger reasons for holding. Previous.
Even para 5, it says should be held to be continuing in force.
Yes.
And then 6.
7, in fact, 6 and 7.
6 says that the second submission based on 2 of Article 370 does not find support even from the language of that clause, which only refers to the concurrence given by the government of the state before the Constituent Assembly. And makes no mention at all of the completion of the work of the
Does
Constituent
not
Assembly.
find support even from language of that clause, which only refers to concurrence given by a government before the Constituent Assembly was. That's what I'm submitting. No, that's a very limited. It's a temporary provision within a temporary provision.
But this seems to give the seems to hold that the article in its entirety would continue to govern even after the Constituent Assembly had completed its task.
No, not as a whole.
Read 7.
Just para 7.
Let me read it, Lord. Your Lordship may allow me to complete.
Yes.
There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after Constituent Assembly of State had passed Constitution. The most important provision in this connection is contained in clause 3 of article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as President may, by public notification, provided recommendation of Constituent Assembly of State referred to in clause 2 shall be necessary before President issues. This clause clearly envisages that article will continue to be operative and can cease to be operative only if, on the recommendation of Constituent Assembly of the state, President makes a direction to that effect. In fact, no such recommendation was made by Constituent Assembly of the state, nor was order made by President declaring article shall cease to be operative. On the contrary, that's important. It appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in the article was notified by the President by Ministerial Law Order dated 15 November 52 and laid down that from 17 November, article was to be operative with substitution of new explanation for old explanation. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article by making a recommendation it should be operative with modification only. Lord, it can't be, you can't now resort to 373 to repeal it. Constituent Assembly has accepted, it's a one-time exercise. Lord.
Not repealed.
President acted upon it.
It is not repealed, Mr.
No, it becomes inoperative.
So from time to time, this is what I said earlier, time to time COs have been issued.
No, we are not on 371. I am on 370 subarticle 3.
Even the present exercise, other argument being open, it is not removed. It has applied the other provision. As it exists in the statute of the Constitution.
No, Lord, they have repealed it. They have deleted it. They have exercised 373 to delete it.
All
The word
provisions,
is- I'll just tell you.
now as it stands is, all provisions of this Constitution amended from time to time still will apply.
Yes, bro, they have abrogated 370 and applied all the provisions of the Constitution. Both they have done. That part was not permissible. Now see further new.
So Dave,
Hmm.
we can just go a little earlier. Paragraph 4.
Yes,
First argument and the second argument that will clarify the situation.
the-
It's at page number 29, 28 rather. The first argument
Yeah.
was that the
first
article,
argument was that this article contained temporary provision which ceased to be effective after Constituent Assembly convened for purpose of framing Constitution of JNK had completed its task by framing Constitution. Reliance was placed on historical background in 370 included so and so. Then Lordships may omit. The answer is what
and then it goes also as you have done. And in this background, then it's stated that background Article 370 could have been intended to remain effective till the constitution of the state was framed and the people of Jammu and Kashmir had been expressed, and thereafter must be ceased to have become ineffective so that modifications made by the president of
without authority. Now see the answer. I'm grateful to your Lordships. Your Lordship said no. But we are not on that. It's not our contention that 371 doesn't apply or president can't exercise powers under 370 as sub-article 1. As not recorded in at page PDF page 31 para 7. That's the answer. That it was not left to the Constitutional Assembly, otherwise it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation, or the president will make a recommendation, or parliament will resolve. Here what they have done is that parliament resolved. That's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373, abrogating it. It's an extraordinary I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power.
Reading right.
Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But Lord, it can't be because that has come to an end. Lord, speaking for Federal Court, Chief Justice Kanya said this, Lord, in 1949 FCR, Lord, Jatindranath Gupta versus Bihar, Lordships are aware of that judgment. As a general rule, and unless it contains some special provision to the contrary, after a temporary statute has expired, no proceedings can be taken upon it as it ceases to have any further effect. 373 is that. 1949 FCR 595. It's at volume 30, plot page 18. I'm not going to trouble reading it. But this is a state, and this has been recognized subsequently. Even General Clauses Act doesn't apply. Your Lordship said to temporary statutes. And Article 367 expressly begins with a non-obstant clause subject to the contrary. Article 367 begins with a non-obstant clause, says subject to the contrary, unless context otherwise requires. Now, Lord, 370, therefore, context is completely different.
Does apply. Section 21 will apply, the court has said.
I am looking to the statute and making submission on, because the federal court judgment was not granted. I'm sure you will get opportunity.
No, this judgment says that the General Clauses Act will apply. Actually.
Yes, I have seen that. Lord. I have seen that. I have marked that portion also. But Lord, my respectful submission is that here, because of the context of 373, I respectfully submit that in respect of sub-article 3, there is no question that it should apply. Now, Lord, one judgment that I would like to place before your Lordships for consideration is, Lord, so Lord, this is my second my argument that Lord 370, Lord, sub-article 3 stood exhausted, and therefore President Lord neither could exercise powers nor could Parliament recommend to the President to exercise that power. Now, Lord, just to look at the counter affidavit which has been filed on behalf of Union of India. Lord, common counter on all, it says, Lord, it's a counter which is for all, a comprehensive counter, they call it. PDF file, common counter.
This will be in the paper book, right?
Yes.
501.7.
Oh, 501.7.
Thank you, Mr. Gordon.
501.7.
Suryakant has. Mr. Courtmaster, kindly.
Page
PDF?
2990.
2990.
Which is the internal page. So the way?
Lord, Lordships may kindly turn to page 13. Do your Lordships have page 13?
It will be 3104.
Sub-para 7. 7. 7 or 8? What is it? 8. As has been explained in greater detail.
Just 1 second.
Para
PDF
5.
16, Mr. Mehta.
3005.
At page 13.
Para 7.
A page of 3005.
PDF,
Para 7, kindly turn to para 7.
PDF 3005.
As has been explained in greater detail in later paragraphs of this affidavit, it was observed over years. Existing regime under Article 370 and exemptions modifications carried out to the provisions of Constitution of India by presidential orders issued under 371D were impeding rather than enabling, facilitating full integration of erstwhile state of Jammu and Kashmir with rest of the country, which was neither in national interest nor in interest of state of Jammu and Kashmir. How impeding? Somebody makes a statement from Home Ministry, now giving no detail as to how it has impeded. Law and order problems certainly exist, but it is not because of applicability or otherwise of the Constitution. Now, please turn over, Lord, kindly turn to paragraph, straight away to paragraph, Lord, page 18. Page 18. Part of para 8, no? Roman 5. Lordship said that? Page 20 perhaps, PDF page 20.
Mr. Dave, are you inviting the court to review the wisdom of the decision of the government on the abrogation of 370? So you're saying that judicial review should reassess the basis of the government's decision that it was not in the national interest to continue with Article 370.
Chief Justice Chandrachud said in A.K. Roy that not this theory that was developed in United States Supreme Court that political decisions courts shouldn't go into. That is now court. That was given and in Odial, your lordships expressly rejected that argument.
But judicial review would be confined to a constitutional violation. Constitutional violation, certainly it's amenable to judicial review.
Lord, I would respectfully submit that even subject.
There's no doubt that if there's a constitutional violation, this court has a jurisdiction to review. Of course, that's undoubted.
Let me put it this way. President is undoubtedly exercising powers under 370, purportedly. In Samsher Singh, your lordships have said that president can only exercise presidential power in constitutional sense. No other sense, not personal.
But the wisdom underlying the decision to abrogate.
There is no question of wisdom. President can only look at 370. President has to be advised by his advisors that 373 it does not exist today.
Then we are back therefore to the constitutional argument.
President,
constitutional argument, of course, judicial review is available, and we are addressing ourselves to that. There's no doubt about it.
Your lordships are right. I am on fraud on constitution that president is today exercising the power without any material whatsoever, without any justification whatsoever, and to wish it away by simply saying that it was impeding. But surely this court is not going to accept that kind of a very cavalier affidavit on part of Union of India. Yes. Say.
370 would
Argument was this, that these are political questions, don't go into it. Your lordship said nothing going, we will go into them. And now after Bomai, your lordships have expanded the horizon. Your lordships have gone to an extent. What I now just see two more things in this affidavit. Kindly turn to paragraph 15. It's a bundle of contradiction, their affidavit.
Paragraph 15?
Yes.
What PDF page will that be?
PDF 25. Oh, thank you, Mr. Pope.
3015.
I state and submit that Constituent Assembly of erstwhile State of Jammu and Kashmir did not in any manner deviate. Please see that, Lord. Did not in any manner deviate from provisions of Constitution of India, which would be applicable to erstwhile State of Jammu and Kashmir. The Constitution of J&K adopted by this Constituent Assembly included Section 3, which unequivocally stated, State of Jammu and Kashmir is and shall be an integral part of Union of India. Additionally, Section 5 stated, executive and legislative power of state extends to all matters, except those with respect to which Parliament has power to make laws for state under provisions of the Constitution of India. There can be no doubt
By the way, do we really need to labor on the counter? We have to interpret the constitutional provision as it stands. How is this relevant?
Your lordships are right. I'm submitting that, Lord, there are no reasons available in presidential exercise, nor are they given in Lord counter. It's bereft of many reasons, the whole entire
That's
exercise.
really.
That's my respectful
Yes.
sir. Now see last sentence. There can be no doubt, therefore, Jammu and Kashmir became integral part of India, and Constituent Assembly, an elected body, had also given its imprimatur to the provisions of Constitution of India. Now, Lord, please see in this regard, Lord, two decisions. Lord, kindly turn to the judgment of Lord. Lord, Lord, on fraud. Just see, Lord, one paragraph of this judgment.
Now, what are you referring?
Lord, this is the Constitution bench judgment in Mudaliar on Lord, fraud on the Constitution. Just see, Lord, this interpretation, and then I'll take to the next.
Where will we get it, Mr. David?
Volume 28, case law, volume 28, page 8, and relevant part at 15. 8 at 15.
Volume
28, case law compilation.
This leads. Oh, PDF page 19, I'm sorry.
Page 9.
This leads us to the consideration.
Mudaliar is at page, internal page 7, right?
16.
Just see at page 19. Open PDF, then there is
8 at what para?
para
Para
16.
16.
This leads us to the consideration of the question of scope of doctrine of fraud on power. In Gajpati Narayan, Mukherjee, Justice Mukherjee, as he then was, explained the doctrine. It may be made clear that outset doctrine of colorable legislation does not involve any question of bona fides or mala fides. The whole doctrine resolves into a question of competency of a particular legislation. If legislature is competent to pass law, motives which impelled it are irrelevant. On the other hand, if legislature lacks competency, question of motive does not arise. Whether a statute is constitutional or not is thus always a question of power. Learned Judge describes how legislature may transgress the limits. Now, this is important. Such transgression may be patent, manifest, or direct, but it may also be disguised, covert, or indirect. And it is to this later class of cases that expression colorable legislation has been applied in certain judicial pronouncements. Now, Lord, in DC Vadba, your lordships go further, and that is at page. Parliamentary recommendation, Lord, in my respectful submission, suffers from complete colorable exercise of parliamentary powers. It was neither exercising constituent power under 368 nor any legislative power. Resolutions are passed by Parliament on many issues, sometimes not even to honor some individuals or to say some other things or to recognize great events in the country. So Parliament here passes resolution and says, Mr. President, you kindly do this. That, brought in my respectful submission, is a pure act outside parliamentary broad powers. And they did it only because the assembly was dissolved, purporting to act as assembly of JNP. That we are now, since assembly is dissolved, therefore president has the powers and parliament therefore has powers under 356. Page. What? Volume 19, my lord. Page 118. Just one para. That one para. Lord, para 7, PDF page 131.
Which judgment is this?
Lord, this is DC Vadwa
1 second. Page, PDF page?
of volume 19, 118 at 131.
No, that's some other judgment.
This
That
state of
is-
Tamil Nadu.
That's state of Tamil Nadu versus Padmavati Ammal.
Volume 19.
19.
BF 131, I think 131.
One.
Volume 19. You are referring to DC Vadwa?
Yes, my lord.
Yes, difference.
So we have some other judgment.
No,
Padmavati Ammal.
Yes, Padmavati.
19 page, what is the PDF page number?
Oh, yes, it's 118 actually. It's immediately after that. It's 118.
9859.
Page 118 at 131.
131, para 7. When does it begin?
State of Tamil Nadu क्यों होगा?
हाँ नहीं उसके बाद में
No trouble, your lordships, reading that. The emergency power of the governor was not in the context of ordinances, but just above where Justice Mukherjee's dictum in Gajpati Narayan is cited, just above that,
At-
4 lines above that,
at page 133. Huh?
133. It is settled law. No, this is what I place for your lordship's kind consideration. It is settled law that a constitutional authority cannot do indirectly what is not permitted to directly. If there is a constitutional provision inhibiting the constitutional authority from doing an act, such provision cannot be
Yeah.
allowed to be defeated by adoption of any subterfuge. That would clearly be a fraud on the constitutional provision. This is precisely what was pointed out by Justice Mukherjee. And that's my respectful submission that Lord and Lord Mudaliar is also considered. Now, Lord, last judgment that I placed for your lordship is the UP Assembly case, volume 30,
This was
PDF page 73.
33, page 1. This
Here, volume 30, PDF 73 at 92.
Volume?
38. Volume 30, my lord. Volume 30. So, Lord, this is the special reference.
PDF?
PDF 30. Sorry, PDF 73. Volume 30, PDF 73 at 92, para 38.
What's the name of the case?
Yeah.
What is that? Any powers, privileges, and immunities of state. UP case.
What page are you referring to?
So Lord, at para 38, 92.
92.
Page 92, para 38.
In dealing with this question.
Yes, ma'am. Grateful. All your lordships have that? My Lord Justice Khanna?
Just give me a minute.
Yes.
Paragraph number?
38.
38. Okay. Yes.
In
got it.
dealing with this question, it's necessary to bear in mind one fundamental feature of federal constitution. In England, parliament is sovereign, and in words of Dicey, the three distinguishing features of the principle of parliamentary sovereignty are that parliament has right to make or unmake any law whatever, that no person or body is recognized by law of England is having a right to override or set aside legislation of parliament, and that right or power of parliament extends to every part of Queen's dominion. On the other end, essential characteristic of federalism is distribution of limited executive, legislative, and judicial authority among bodies which are coordinate with independent of each other. Supremacy of constitution is a fundamental to existence of a federal state in order to prevent either the legislature of federal unit or those of the member states from destroying or impairing that delicate balance of power. That's precisely what has happened, destroyed the delicate balance of power, which satisfies the particular requirements of states which are desirous of union, but not prepared to merge their individuality in unity. Lord, you can't rewrite history. And a constitutional history can certainly be never rewritten. That's why it's durability. This supremacy of constitution is protected by the authority of an independent judicial body. Your lordships, independent judicial body to act as interpreter of a scheme of distribution of powers, nor is any change possible in the constitution by the ordinary process of federal or state legislation. Ordinary process, 370, President issues, Parliament pass resolution.
Yes, Mr. Ray.
Thus, the dominant characteristic of British Constitution cannot be claimed by a federal constitution like ours. Then what next paragraph? Our legislature have undoubtedly plenary powers, but these powers are controlled by basic concepts of the written constitution itself and can be exercised within legislative fields allotted to their jurisdiction by 3 lists under the 7th schedule. But beyond the list, legislature cannot travel. They can no doubt exercise their plenary legislative authority and discharge their legislative functions by virtue of powers conferred on them by relevant provisions of the Constitution. But the basis of power is Constitution itself.
Yes, Mr. Davi, we read that. Thank you. Which is the next judgment, Mr. Davi?
Followed one sentence, followed in
Yes.
paragraph 40, last sentence, PDF page 93. Therefore, there can be no doubt that the sovereignty which can be claimed by Parliament in England cannot be claimed by any legislature in India in the literal absolute sense.
Yes.
इसके राइट हैंड में पीछे जो है ना प्रशांत
So,
भूषण बैठे हुए
Whichever way one looks at it,
लिए शायद ये आर्गू कर रहे हैं
your lordships may look at the UP assembly case, or your lordships may look at Samsher Singh's case. If not, the exercise of power by the constitution or by the parliament has to be done under the constitution itself and in the constitutional sense, then in my respectful submission, Lord, constitutional sense or constitutional provisions prohibited both the president and parliament from touching Article 370, sub-Article 3 in any manner to abrogate it. There is no power to abrogate Note 370 under 373 because, Lord, as I respectfully submitted, that, Lord, it has lived its purpose, its object, and therefore it no longer is, Lord, available for exercise. In any case, the exercise, Lord, suffers from a fraud on the Constitution because, Lord, it has been done completely contrary to constitutional provision. And, Lord, the principle of federalism, principle of democracy, which, Lord, Bombay has so beautifully, Lord, ascribed. Because ultimately, that's why constitutional framers were very conscious. Let the people of Jammu and Kashmir decide how they want their relationship. They decided for all times to come. It was not a temporary exercise by Constituent Assembly. That's why I said, Lord, it would be travesty of justice that Constituent or Legislative Assembly of Jammu and Kashmir were now to be given authority to say that no, Constitution of India will not apply to us. That power also for them stands exhausted. So, Lord, those are my respectful submissions. Therefore, I respectfully submit. Lord, there is one aspect which, yes, I must tell you. Lord, in my written submissions, I have quoted, Lord, from the 2019 manifesto of the Bharatiya Janata Party. In that, Lord, they expressly said that we will work towards abrogating Article 370.
manifesto
in my respectful submission,
20
this court has already said, Lord, in 2013 judgment, that these manifestos can't be contrary to constitutional scheme. One, and directed EC to issue guidelines. 2015 EC issued guidelines and told all political parties that your manifestos must be within the constitutional scheme and spirit. Now, Lord, today, because you have majority in parliament, you have done not for any purpose. So what is argument of impeding, etc., is not relevant at all. It doesn't exist. The only reason you have done it because you told people of India to vote for you because I will go and abrogate Article 370. That not shows that the power has been exercised for colorable considerations. The actual exercise is not fraught with clearly what I would say irrelevant considerations which cannot apply to broad constitutional exercise. The president is not a rubber stamp. He had to see this. Yes, you have the majority in parliament, but majority doesn't speak broad. It's not a constituent power. You didn't want to go therefore to the majority of both houses of parliament. You didn't want to do that. You didn't want to go to legislature because you are now taking away out of 5 Lok Sabha members and 4 Rajya Sabha members. Once you divide territory, those members, that representation is gone. If the representation is gone by virtue of Article 368(1), you are supposed to go to all many state legislatures and take their approval because they are also concerned. 368 is very beautifully worded. There are so many safeguards in it. So, those are my respectful submissions.
Thanks, Mr. Dave.
Deeply obliged.
Thank you, Mr. Dave. Who will argue now, Mr. Thank you, Mr. Mr. Dwivedi will argue.
दोस्तों, अब आपने देख लिया कि ये किस तरीके से बातें करता है और क्या चाहता है। अगर मेरे हिंदुस्तान में हजारों फौजी अपनी जान हथेली पे लेकर के बॉर्डर की सुरक्षा करते हैं, जम्मू कश्मीर में कितने नौजवान ऑफिसर्स और जवान मारे गए हैं, इनकी चिंता इनको नहीं है। ये लोग शुरू से ही लाइब्रेरी में बैठ करके किताबें पढ़ते हैं और सुप्रीम कोर्ट में जाकर के लाखों रुपए की कमाई करते हैं और इस तरीके से बातें करते हैं। क्या कह रहे थे, क्या सुन रहे थे, उसके बारे में आपको ही देखना है। दे वांट टू टर्न द क्लॉक बैक, जिससे कि फिर वहां पर पत्थरबाजी हो, रोज हुड़दंगबाजी हो और लोग बाग मारे जाएं। दे ये चाहते हैं। इन प्रसाद भूषण, कपिल सिब्बल, दुष्यंत दवे, गोपाल सुब्रमण्यम और डॉक्टर राजीव धवन जैसे लोगों से आपको बचना है। यही मेरी आपसे प्रार्थना है। काफी लंबा हो गया वीडियो, करीब 3 घंटे होने वाले हैं, इसलिए मैं इस वीडियो को यहीं पे समाप्त करता हूं। अगर ये वीडियो आपको अच्छा लगा हो तो आप इसको लाइक करें, शेयर करें और मेरे चैनल को सब्सक्राइब करें। मिलते हैं अगले वीडियो में किसी और मुद्दे के साथ। धन्यवाद। जय हिंद।